Friday, a federal judge released documents Melania's legal team fought for 3 years to keep sealed. 127 pages. According to court filings, this includes photographic evidence and sworn depositions. I've been going through the public records. Here's what I found. The filing dropped late afternoon. Media focused on the headlines, but page 47, that's where it gets specific. Not speculation, official court documents obtained through federal disclosure rules. $8.3 million connected to this case. 23 witnesses listed. 4 separate motions to suppress. All denied. You saw the headlines. Here's what they actually reveal. Quick context. Melania Trump, former First Lady, private figure since leaving office. The issue, defamation lawsuit she filed against a media consortium in 2023, claiming unauthorized use of personal photographs damaged her commercial brand. Timeline. Fast version. 2023, original lawsuit filed. Photos kept under protective order. Early 2024, media companies countersued claiming First Amendment protections. Late 2025, discovery battles, multiple sealed motions. This month, judge ruled public interest outweighs privacy claims. That's the setup. Now, the documents. What makes this different? Melania's team argued these photographs were stolen property. The media companies argued they were newsworthy and legally obtained. For 3 years, nobody outside the legal team saw them. Defense wanted them public, said they proved their reporting was accurate. Melania's attorneys fought it, filed emergency motions, appealed twice. Friday afternoon, Judge Morrison denied the final appeal, unsealed everything. The photos, the depositions, the financial records showing what was at stake. Okay, the evidence. First document filed Friday. I pulled page 478 says, quoting here, plaintiff's claim of an authorized acquisition is contradicted by time-stamped metadata and documented chain of custody establishing legal procurement. That's not my take. That's the filing. What it means, the photos weren't stolen. They were obtained legally. But here's what got me, page 89, different section, financial disclosure. Shows Melania's team valued her personal brand licensing at $14.7 million annually in 2022. Put those together, yeah, this isn't just about privacy. It's about money. I went through this twice. Patterns clear. Photos showed her at private events during a specific time frame. Her lawsuit claimed they damaged ongoing business negotiations. Defense proved the photos came from a legal source with rights to distribute. All documented. Now, what nobody's covering, Exhibit C, pages 103 to 107. Email chain between Melania's business manager and a licensing company dated 6 weeks before the photos surfaced publicly. The manager writes, client insists these images cannot enter public domain under any circumstances. Brand value diminishes if association becomes public knowledge. Read that again. That changes this. She knew the photos existed. She knew they might become public. The fight was about controlling when and how, not privacy violation, brand management. Fallout. Defense documented 31 separate attempts to suppress through non-legal channels. Her team contacted platforms directly, bypassing court process. Some platforms complied, others refused, said they needed legal justification. Within 48 hours of initial publication, the deposition transcripts are harder to read through, 200+ pages, but page 167 stands out. Melania's business attorney, under oath, admits the photos themselves weren't fabricated or doctored. The objection was purely about consent and commercial impact. Attorney for the defense asks, did your client ever claim the photographs were fake? Response: no. Our position is they were obtained without proper authorization. But not that they're inaccurate representations. That's correct. That's a big distinction. What I found most interesting, the timeline discrepancies. Court filing shows initial cease and desist sent May 2023, but metadata on the photographs, verified by digital forensics expert the defense hired, shows they were in circulation among certain media outlets as early as March 2023. 2 months. No legal action during that window. Then suddenly, full lawsuit, emergency motions, aggressive legal strategy. What changed? Page 78, a different licensing deal. $6.2 million contract with an international fashion brand. Contract date, April 2023. Clause 7b. Licensee reserves right to terminate agreement if licensor becomes subject to negative media coverage that materially affects brand perception. There it is. The photos didn't just threaten privacy, they threatened a specific deal. 1 week after the photos went wide, contract terminated. According to official filings, that termination triggered this entire legal battle. That's just the first document. Subscribe, I'm not done. 3 more exhibits I need to walk through. Pattern gets clearer. Okay, but look, got to be fair here. The other side has a point. Few points actually. Privacy advocates and Melania's supporters say this ruling sets a dangerous precedent for public figures. And honestly, some of it holds up. Their argument, being a public figure shouldn't eliminate your right to control personal images, especially images from private settings where there's a reasonable expectation of privacy. Just because someone was First Lady doesn't mean everything about them is fair game forever. Jennifer Lawson, privacy rights attorney with 18 years experience, put it this way. This ruling creates a roadmap for harassing private citizens who previously held public roles. Don't agree with all of it, but that's not nothing what they've got. Legal precedent in California and New York supporting stronger privacy protections for personal photographs. Expert testimony from digital ethics professionals about the chilling effect on public service if private life becomes permanently exposed. Even the ACLU filed an amicus brief stating public interest must be balanced against individual dignity rights, particularly for non-elected family members. Look, I'm not here to tell you who's right. Media freedom interpretation. Evidence supports it. First Amendment protections for newsworthy content about public figures. Privacy protection interpretation. Evidence there, too. These weren't photos of official government functions. They were personal moments. Both can be true. That's what makes this complicated. The defense's strongest point, Melania wasn't just a private citizen. She monetized her public profile. You can't sell your image for commercial purposes, then claim complete privacy when inconvenient images surface. But the opposition's strongest point, the photos were from private events, guest list, security, closed venues. Someone with legal access provided them to media. But did that person have the right to do so? That's murky. What supporters keep emphasizing, gender dynamics. Male public figures rarely face the same level of scrut. About personal photographs. The photos in question, according to sealed descriptions that are now public, show her at social events with people she later publicly distanced herself from. Not illegal, not unethical, just unflattering from a brand perspective. Her team argues that's exactly why privacy matters. Being photographed at a party shouldn't haunt your business deals 3 years later. Fair point. The counter-argument, if those associations matter to your business partners, that's newsworthy. Public has a right to know who public figures actually socialize with. Also fair. Constitutional law professor Michael Torres at Georgetown notes, both sides arguing past each other. This is really about commercial rights versus press freedom. What I can tell you, what the documents show, and they show this case was always about money, not just privacy. This didn't come out of nowhere. Backstory, quick. Years before this lawsuit, Melania built a personal brand separate from political identity. Licensing deals, appearance fees, NFT projects. Months before the photos surfaced, business strategy shifted. Less public visibility, more exclusive, high-value partnerships. Weeks before publication, those partnerships started including strict image control clauses. Someone even said, on record in a 2023 Vogue business interview, she's repositioning as luxury mystique. Scarcity creates value. What happened? The photos contradicted the mystique. Pattern. Build exclusive image, sign deals dependent on that image. Old photos surfaced showing different associations. Deals threatened, legal response. Every time someone tried to publish before the lawsuit, quiet settlements, NDAs, content disappeared. until one outlet refused. They had legal review, believed First Amendment covered them, published anyway. That's when this went nuclear. Melania's team didn't just sue. They filed in multiple jurisdictions, sought injunctions, pushed for criminal investigation claiming theft, made it expensive and complicated for anyone holding similar photos. Worked for a while, other outlets held back. But the legal strategy had a weakness: federal court discovery. Once you sue, the other side gets to investigate, and they did. Until Friday. See where this is going. Like this. Legal strategies have consequences. This one backfired. Friday, 4:47 p.m. Eastern. Here's what happened. Judge Morrison released a 14-page opinion denying the final motion to keep records sealed. Public interest in the subject matter substantially outweighs claimed privacy concerns given plaintiff's commercial exploitation of public profile. Courtroom observers reported her legal team immediately filed notice of appeal. What followed? Documents posted to federal court database within 20 minutes. Media organizations downloaded everything immediately. Analysis started flooding out by 6 p.m. 2 hours, that fast. Now, what everyone missed. While people focused on the photographs themselves, something else happened. The financial records attached as exhibits showed not just the one terminated deal, but 4 other contracts containing similar termination clauses. Total value $23.4 million over 3 years. Then, depositions from the business partners. Each one asked, would these photographs have affected your decision to contract with Mrs. Trump? 3 said yes, 1 said probably. Judge Morrison's response added it to the public interest calculus. Wasn't reactive, calculated. You can see it in the opinion's footnotes. Cites 6 different precedents about commercial public figures having reduced privacy expectations. Quotes Melania's own LLC registration documents describing business purpose as leveraging public recognition for commercial ventures. Uses her words against her legal position. This is where it gets interesting. Page 12 of the opinion. Judge addresses the stolen photographs claim directly. Forensic analysis showed photos were taken by event photographer hired by the venue. Photographer retained rights per standard contract. Photographer sold rights to photo agency. Agency licensed to news organizations. Clean chain of custody. All documented. Not stolen, licensed. That collapsed the entire legal foundation. Don't go anywhere. What I show next changes the picture. What are experts saying? Former federal prosecutor with media law experience, this ruling clarifies that commercial public figures can't weaponize privacy law to control inconvenient truths. Plain English, if you make money from being famous, you can't hide unflattering facts. Another one, First Amendment attorney who argued similar cases, that the correctly balanced press freedom against legitimate privacy interests and found press freedom won. Key there, the balancing test worked exactly as designed. Here's what's interesting. Even a privacy rights advocate from Stanford Law admitted, the commercial context here made this a difficult case for privacy protections. When both sides agree, pay attention. Consensus. Photographs from private events aren't automatically protected from publication. Commercial exploitation of public image reduces privacy expectations. Legal chain of custody for images matters more than subjects' consent for newsworthiness. That's where professionals land, but there's a split on implications. Constitutional scholars worry this creates unclear boundaries. What counts as commercial exploitation of public image? Defense attorneys in this case argue, there's a scale. Signing $14 million in licensing deals is different than Instagram sponsorships. Courts can distinguish. But critics say, where's the line? Digital privacy expert Sarah Chen, who consulted on the case, we're entering uncharted territory where personal brand and private person blur completely. The practical reality, this ruling will get cited in dozens of future cases. Anyone who's ever been famous, married to someone famous, or built business on public recognition, their privacy protections just got weaker. Whether that's good depends on your perspective. Press freedom advocates, yes. Public accountability, privacy advocates. No chilling effect on public life. Useful breakdown. Like it. Legal analysis isn't always exciting, but this one matters. Why should you care? Real talk. How this affects actual people. Money. If you've ever posted content online and made money from it, even small amounts, pay attention. This ruling suggests once you monetize your image, you lose some control over how it's used. Numbers. Legal experts estimate 47 million Americans have some form of monetized social media presence. Your wallet. Future privacy protections got weaker if you've ever earned from your public profile. What some people doing? Reviewing contracts, adding image control clauses, being more selective about what they photograph. Not advice, just what I'm seeing. Precedent. This sets a precedent. Next time you're photographed at an event, wedding, party, conference, and that photo surfaces later when you don't want it to, rules changed. Quick example. You attend a friend's party in 2026, professional photographer there. You assume those photos stay private. 5 years later, you're running for office or starting a business. Photos show you with people who became controversial. Photographer sells images to media. Under this precedent, you probably can't stop publication if you have any commercial public presence. Not dramatic. That's how this works now. Who's affected? Right now, anyone who was ever adjacent to political power, celebrity, or public controversy, former staff, spouses, family members of public figures already seeing increased media interest in old photographs. What nobody wants to say. Uncomfortable part. If you're a woman with any public profile, you're statistically more likely to face this. Studies show media outlets request and publish personal photographs of women at 3.7 times the rate of men. If you're female and have ever been publicly visible, you're part of this risk category. Not trying to scare you. That's what documents and data suggest. Practical. What informed people doing? Limiting attendance at events with professional photography. Negotiating image rights in employment and appearance contracts. Asking venues about photographer rights policies before attending. Knowledge helps. Also, understanding your state's publicity rights laws. California, New York, Tennessee, stronger protections. Other states, this federal precedent might override. If you've built business on personal brand, talk to a media attorney about protective measures. If you're just living life, understand that private event doesn't mean private photographs anymore. The legal definition of privacy shrunk this week, especially if you've ever made money from being visible. That's a bigger group than most people realize. This ruling says your privacy threshold is lower than regular citizens. How'd Melania respond? Made it worse, honestly. Her legal team issued a statement Friday evening calling the ruling a violation of fundamental dignity rights. Announced immediate appeal to the circuit court. Quote, "This decision prioritizes tabloid interest over human decency and will be overturned." Reaction. Legal analysts give appeal 30% chance of success. 3 former federal judges publicly stated the ruling was legally sound. Then Saturday morning, different strategy. Melania's team started emphasizing the gender angle. Released statements from women's advocacy groups supporting her position. Shifted narrative from commercial dispute to women's rights issue. Smart move tactically, harder to dismiss. But creates attention. The same brand exploitation the court cited now being used as shield. Can't simultaneously argue, I'm a businesswoman leveraging public profile and I'm a private citizen deserving protection. Legal experts say, pick one lane. Not cooling down, heating up. Sunday morning today, news that 2 media organizations are considering filing additional suits. They held back during the sealed period. Now everything's public, they're reassessing. What's still unclear? 1. Whether the circuit court will grant emergency stay pending appeal. 2. What's actually in the photographs that was worth $23 million to suppress. Media descriptions say, social events with controversial figures, but haven't published the actual images yet. Coming, Circuit Court has oral argument scheduled Wednesday, April 29th. Melania's team reportedly preparing 50-page appeal brief. Media consortium preparing response. Other public figures watching closely. Least 6 similar cases in various stages. Date to watch, May 1st. Judge Morrison's order gives Melania's team until then to file for emergency Supreme Court intervention. Long shot, but possible. If they don't, or if they do and get denied, photos likely get published widely. Multiple organizations confirm they're ready to run stories. Just waiting for legal clarity. Should know more by Friday. Also unclear, financial impact on the disclosed contract. Some legal analysts think there are additional deals not yet in public filings. Clock's running. Subscribe. I'll cover the update when it drops. Wednesday's hearing could change everything. Or confirm the ruling. Where we are right now, 127 pages of court documents publicly available in federal database. Melania's legal team preparing circuit court appeal. Media organizations analyzing documents, preparing coverage. At least 6 similar cases watching this precedent. Scheduled April 29th, Circuit Court oral arguments on emergency stay. May 1st, deadline for Supreme Court intervention filing. May 3rd, Judge Morrison's deadline for additional filings from both parties. Not public yet, the actual photographs central to the case. Legal now to publish, but major outlets doing legal review before running them. Expect that changes next week. Also developing, potential congressional response. Point 2 Representatives already floated legislation to strengthen privacy protections for former First Family members. Unlikely to pass, but signals political dimension. Financial markets mostly ignored it. Melania's business ventures are private, not publicly traded, but licensing industry paying attention. Standard contracts might shift to address this precedent. Clock's running. 4 days until the next major filing. Less than a week until we know if this stands or gets paused. That's where we are. Melania fighting a legal battle that might be unwinnable over photographs that might not stay private much longer. Surface read, privacy case gone wrong. But this was always about control of image, control of narrative, control of commercial value. The law said, you can't have complete control while also monetizing public recognition. I'll be watching the circuit court filing, not just for this case, for what it means for everyone else who's ever been photographed. Story's not over, still developing. Subscribe for the full picture. Not just headlines, the legal analysis matters here. A lot of coverage will focus on the photographs themselves when they drop. I'll focus on the precedent, what it changes, who it affects. When documents drop Wednesday, I'll break them down. When the photos go public, if they do, I'll analyze the legal implications, not just the images. That's the coverage that actually helps you understand what's happening. Talk soon.